Major Supreme Court ruling.
Major ruling involving the Second Amendment.
The Supreme Court has just issued a major ruling.
It's a case that legal experts will be watching closely when it likely heads before the justices.
Gun laws don't usually flip regular, law-abiding people into felons overnight. But this one gets real close. Starting in 2026, owning the wrong semi-auto with the wrong feature in the wrong state can land you in prison for up to 10 years, even if you never broke a single other law. I'm Tommy from the Armory, and today I'm breaking down how this new wave of gun laws actually works, why court challenges won't protect you in time, and how a firearm that's perfectly legal today can absolutely wreck your life tomorrow if you're not paying attention. Before we dive in, do me a solid. Smash that subscribe button, tap the bell, hit all the dang buttons down there. You don't have to, but it keeps this train rolling and lets me keep cranking out this wild gun talk for y'all. All right, enough of that. Let's get back to it. The countdown starts. 2026 is not far away. The clock is ticking. 2026 is when a lot of wait-and-see gun talk turns into real deadlines with real penalties attached. These aren't just proposals. These laws have effective dates baked in. And once that date hits, the rules change, even if a lawsuit is still pending. That's how this works in the real world. Take Rhode Island. The state signed a ban that kicks in July 1st, 2026, and it's built around the modern feature test model. If a semi-automatic rifle accepts a detachable magazine and has the listed add-ons, it drops straight into the prohibited bucket. The penalty language? Felony level. Up to 10 years in prison and up to $10,000 in fines. That's not commentary. That's written directly into the bill text. Colorado's different path, same deadline. Colorado takes a different route, but the switch still flips in 2026. Starting August 1st, 2026, Colorado restricts the sale and purchase of certain semi-automatic firearms. Their framework ties lawful purchases to state-sanctioned safety training, an eligibility process, and background checks with private transfers forced through licensed dealers. That means buying and transferring starts looking a whole lot less like two adults making a legal sale and a whole lot more like show paperwork, stay in your lane. Paperwork is enforcement. Ask New York. In places like New York, assault weapon compliance already comes with recurring recertification cycles, registrations tied to 5-year renewal rules. That matters because enforcement usually starts with paperwork first. Not raids, not violence. Paperwork. So if 2026 sounds far away, it's not. The smart play is treating this like a countdown. Know the effective dates, know what you own, know what your state calls an assault weapon. Because next we've got to talk about how that definition is built and how one single feature is where people get burned. One feature equals felony. When people hear assault weapon, they picture one specific rifle. That's not how these laws work. States write definitions around mechanical categories and feature lists. Same gun, legal in one state, felony in another. That's why 2026 matters. Multiple states are tightening how they draw that line. In Rhode Island's 2025 Assault Weapons Ban Act, the core idea is a feature test. A semi-automatic rifle that accepts a detachable magazine becomes prohibited if it has any listed feature. A pistol grip, a folding or telescoping stock, a flash suppressor. The bill also targets certain semi-automatic shotguns with specific feature combinations. That parts list people argue about online? That's the legal tripwire in the statute. Colorado's category trap. Colorado goes a different direction, but the same what counts problem shows up. Senate Bill 25-0003 targets semi-automatic firearms that accept detachable magazines by forcing you to complete a state-approved training course before you can buy them. And before you even take that class, you need a firearms safety course eligibility card from your county sheriff. That means a background check and fees up front. It's not branding. It's a regulated category. The law controls it. Definitions stick. Paperwork never ends. New York proves the point. The SAFE Act requires registered assault weapon owners to recertify their status every 5 years. State police are crystal clear. Miss that window and your registration can be revoked. That's the reality. Definition is step 1. Compliance is step 2. Once your firearm fits the definition on paper, the punishment section stops being theoretical. Where the up to 10 years comes from? When people hear 10 years, they assume violence. That's not how these statutes read. I'm looking straight at the penalty sections. Felony exposure attaches to possession and transfer once a firearm is legally classified as prohibited. No robbery, no misuse, no intent requirement, just possession after the effective date. Rhode Island is the cleanest example. Under the 2025 Assault Weapons Ban Act, unlawful manufacture, sale, transfer, or possession of a prohibited firearm is punishable by up to 10 years in prison and fines reaching $10,000. That's not rhetoric. That's straight from the statute. How this plays out in real life? States with existing bans show exactly how this works. In New York, failure to maintain registration turns a lawfully owned firearm into contraband. Once that paperwork lapses, possession becomes a criminal offense. Massachusetts runs a similar system where possession of banned or improperly registered firearms carries felony penalties that stack fast, including mandatory minimum exposure in some cases. Here's what really trips people up. Compliance failures get treated the same as deliberate violations. Miss a registration window, store the firearm incorrectly, transfer it the wrong way. The charge doesn't downgrade just because the mistake was innocent. The statute doesn't care. Once the definition catches your firearm, the punishment section becomes the real problem. Grandfathered doesn't mean safe. This is where people get comfortable, and that's dangerous. Grandfathered sounds reassuring, but in most 2026 laws, it just means you can keep what you already legally own while the state clamps down on everything around it, selling it, transferring it, sometimes even where it can go. The paperwork gets messy fast. Rhode Island is the perfect example. Starting July 1st, 2026, the law bans buying, selling, transferring, and manufacturing the defined firearms. If you already own one legally, you're not automatically forced to surrender it, but you don't get to treat it like normal property anymore. Future transfers get pushed toward federally licensed dealers or out-of-state options. That easy private sale to a buddy? Dead. And when you mess that up, intent doesn't save you. Restricted property reality. Same story in registration states. In New York, assault weapon registrations require periodic recertification. Fall off that paperwork cycle, and you lose the legal shield that made the firearm lawful. So when someone says grandfathered, I hear, congratulations. You're now managing a restricted item. Document it, store it properly. No transfer rules cold, because this is where stress lives. When the state decides your compliance mistake is a felony. Ban versus permission systems. States aren't moving in one direction. Some are banning future sales outright. Others are building permission systems. Some are squeezing people through audits and paperwork. That mix is what makes 2026 dangerous. The rules change by zip code, not by gun. Rhode Island is a shutdown model. Colorado is a gatekeeper model. New York enforces through paperwork pressure. Different paths, same risk. The margin for error gets smaller. Courts won't save you in time. Court challenges matter, but they don't automatically freeze laws. Unless a judge issues an injunction, the law stays enforceable. Even then, states can appeal and ask for a stay. I can be constitutionally right and still get jammed up today. Betting your freedom on it'll get struck down later is a bad bet. What I do before 2026? First, I inventory what I own. Then I read my state's definition, not a meme, not a forum summary, the actual statute. Rhode Island's 2025 Act is built around specific features and felony penalties. Colorado's Senate Bill 25-0003 ties purchases to a sheriff-issued eligibility card and track training starting August 1st, 2026. Different rules, same risk. Then I lock down paperwork. If I'm in a registration state, I calendar recertification dates. New York State Police says recertification every 5 years. Miss it, registration can be revoked. I keep receipts for compliant storage gear. I follow transfer rules like my rights depend on it, because they do. And if any of this overlaps my situation, I call a firearms attorney before moving guns or buying parts. A 30-minute consult is cheaper than a felony. With that foundation in place, now we can talk about how enforcement actually hits when these dates arrive in the real world.